started on time. I think we have everybody present that's going to be present, and Stephen Eldridge is participating by phone this afternoon. Thank you, Stephen, for calling in. And then Andy Bonner has a work-related conflict, so he will be participating via phone tomorrow, but will not be participating in today's meetings. We'll go ahead and get started with the licensing committee, and for that, I realize we'll formalize the committee assignments tomorrow, but currently the folks sitting on that committee include Gay Moon as chair, Pam Church, Stephen Eldridge, Greg Gilbert, and Judy Weatherby. And so, Gay, I'll turn it over to you.
Okay. The first item on our agenda is a testing window extension request that has been made by Mr. Krell. He passed audit in the first quarter of 2018. He passed BEC and REG the second quarter of 2018. He has had three times to test for FAR and has been unsuccessful. But the issue with this is that when he registered for FAR in the third quarter of 2019, his dashboard related to NASBA or NTS showed an expiration date of July 31st, 19. And because of that, he rushed to sit for the exam and subsequently failed it. He also found out later that his audit did not expire until September 30 of 19, and he felt like that if he'd had that extra time to study, he would have had a much better chance of success. So he has asked for the audit to be extended until 12/31/2019. At that time, audit, BEC, and REG will all expire if he does not get FAR passed during this last testing window. Also of note is when he got his grades as a result of the July 31 sitting, he was not qualified to sit for it again during that testing period because our potential licensees only can sit once per testing window. So that was another complication related to his situation. So with the facts kind of out there, open it up to discussion and questions.
Have we seen this before where NASBA messed up the data sent to this? I don't recall that we've seen that.
I have not seen an instance. It's been a couple of years, but at one point they were not interpreting our rules correctly with regards to expiration date. So most states only allow till the end of the month once you reach that 18 months, and our rules actually allow you till the end of the window. So they had to revise the way that they were that they're assessing these expiration dates. But to my knowledge, that had been fixed a couple of years ago. So
we confirmed this with NASBA that it happened?
I believe it has been confirmed, and he sent us screenshots of his dashboard.
That's right.
Showing July 31st.
Okay. It just really concerned me that this happened. I'm sympathetic, frankly, because I think if somebody messed up, somebody messed up.
You're on the side of a student?
What?
Are you on the side of a student now?
Yes. Not usually.
I think his request is a very reasonable request. I mean, it's embarrassing to make a mistake like that, and I think we need to find out why it happened and make sure it doesn't happen again. But I mean, I think that given the circumstances, I think it's a reasonable request to give him a one testing window extension to finish.
I agree. Can I ask a question just unrelated or related to that? But is that our rule that doesn't allow them to take it more than once in a window if they fail?
Yes, but that's consistent across the country, yes.
And it's going away.
Well, that's the same. Did we pass, we proposed revised language, right?
Yes, in fact, yes, those were approved by the board back in May, but of course we have to go through the rulemaking process. Right. So we did receive notice actually this morning. Those have been filed with the Secretary of State, and they will be effective in January for whenever the AICPA starts their continuous testing. So, yes.
But we can't allow these students to go ahead and just do it. We have to wait for the AICPA to approve that.
Yeah.
Okay.
It may be delayed. Are they still saying that?
So my understanding is they're still focusing on July 1, but they have 4 to 6 states that are having trouble meeting that deadline, and they're just concerned about it operating fairly different in those states. So there still hasn't been an ultimate decision made, but July 1st is still the focus.
Any way to tell if NASBA made that error with other people? And can they tell us what caused if they could tell us what caused that error on their end, they may be able to. There may have been other people that had.
She said it was a misinterpretation of our.
Some people may not have asked for an exception, and so I hate that.
I can reach out to her and see if she can verify that this was a one-off, or if they can spot check other folks and make sure that that the expiration date's being applied appropriately.
Any other comments or questions? Have a motion to approve an extension by one testing window.
So moved.
I'd
I'm
make that.
making that motion just as a FYI for me. I would put in there due to the misrepresentation of the dates, just so we know in the future that somebody comes and asks us for extension, we know why we did this.
Okay, do we have to make a motion to approve the extension as a result of NASBA's misinformation on the expiration of the audit, his audit test scores?
So moved.
Yes.
Do I need to say that again? I move that we approve this exception on the basis of NASBA's misinformation sent to.
I'll second that.
Discussion? Do we need to do a roll call vote?
Yes.
Okay.
Janet Booker Davis.
It's just the committee.
Oh, I'm so sorry. Pardon me. I have. A. Moon.
Aye.
Pam Church.
Aye.
Stephen Eldridge.
Aye.
Greg Gilbert.
Aye.
Judy Weatherby.
Aye. Next item, Wendy has provided us with a 2019 Tennessee State-Specific Ethics Overview of kind of how it's going. Wendy, do you want to just highlight the main topics?
I'll give a little background and reminder to everyone about how we've been handling the state-specific ethics for the last year or so. It looks like, so we worked out a memorandum of understanding with the TSCPA a couple of years ago where they would create the content. So the course would be created by them, and then other sponsors would be able to purchase the material and present that if they were approved by us to do so. And so the goal there was to make sure that the content was accurate. We had numerous issues with accurate content prior to this, and to really make sure that we were part of the process and could make sure the licensees were hearing the information we wanted them to hear to better comply with the law and the rules. And so in this update, it's just, we meet 4 times a year. This is the one time a year for me to kind of give you an update on how things are going with regards to this. As far as I'm concerned, the memorandum of understanding is being adhered to. TSCPA delivers the course in a variety of formats. You can get it online, webcast, live, pretty much any avenue you'd like. You can get it directly through TSCPA. That online course, I believe, is $35. That's in the memorandum of understanding, if I'm missing that. $35 for that online version. And then what happens is other sponsors want to offer the course, so they come to us first and they fill out an application, which I've included the application in here that we've been using that they complete. They have to agree to have a Tennessee licensee teach the course.
They have to agree that it will be instructor-led. They have to certify that the material will be obtained from TSCPA. They agree to be pre-approved by the board each year. They certify that they will submit their comments and evaluations to the board within 60 days of receipt, and that they will not provide the ethics course after January 1st for the previous calendar year or upon notification by the board that new material is available, whichever date is later. I had an issue last year where we had, or earlier this year, where we had about a month where material wasn't available because we had shut them off January 31st, but the new material with TSCPA wasn't ready yet. So we can't go without having an available course because we have people trying to comply with CPE at all times of the year, whether it be through disciplinary action or just late in getting their CPE or something like that. So in the memorandum of understanding, the TSCPA agrees to submit new content to us each year by, I believe it's March 31st. And then we review and make some revisions there, and then they contact the sponsors when that's available. So in the overview that I prepared for you all, the third bullet shows you the sponsors that we have approved during 2019 and the type of program that they are offering. I'm sorry, it's the Tennessee State Specific Ethics Overview, 2019, sorry. We did reach out to the sponsors on October 10th, reminding them of their requirements to submit the evaluations. We had not received that many this year to date, so I just wanted to make sure everybody remembered they needed to send those in. So at the bottom of that sheet, you'll see the few that we have received. Of course, those of you who have heard Perry Moore always gets very excellent ratings on this course, and that's mainly what you see there. For Beacon Hill and Checkpoint, there's no real specific comments. There's some ratings, which are all positive, but no specific comments have been received. That concludes the overview. If you all have any questions, happy to answer.
I do. I wanted to ask, so these additional sponsors that have been approved, are they using TSCPA's materials?
Yes.
Okay. All right. I just wanted to make sure that you guys weren't having to go through all of their material and look at it as well.
On the application, they are required to attest that they'll get the information from TSCPA, the materials.
How has that lightened the burden for you all? Because that was the goal of the board, was so that you wouldn't have to review lots of material from lots of people offering the course.
Yeah, that is completely gone, having to review that information. So we just do it one time a year now with TSCPA.
That's goal accomplished.
Yeah.
Comments?
So all these people paid these fees over here of either the $5,000 or $500 plus $20 per person. Is that right?
Correct.
Okay.
Okay. Well, this is a perfect segue into the 2020 Tennessee State Specific Ethics Outline. Each year we review the outline, and our staff have made some additions that we will communicate with the Tennessee Society of CPAs, and those additions will be incorporated into the 2020 CPE course. And I'm just going to highlight the changes or the additions that have been made. Under item E, continuing professional education, the last bullet has been added for CPE reporting requirements. Starting with the 2019, licensees will have to submit a list of their courses that they have taken upon renewal. The next item that was added, G, what's new, is going to incorporate the new law and rule changes, specifically the CPE rules that were effective in September. This relates to our classification codes that will be in alignment with NASBA, as opposed to Tennessee state board classifications. And then also, as Wendy was talking about, the continuous testing, that has gotten some approval, so that will be incorporated into the course at some point, I guess when that's final. Then under item H, the second bullet, integrity and objectivity have always been a part of the rules of professional conduct, but they are adding conflicts of interest because we're seeing a few more issues involving that, and I believe our staff is putting together some examples of conflicts of interest that can be incorporated into the course to kind of give people a little pause to think about, be more thoughtful about what they're doing and to recognize that the conflict of interest is an issue. And then the last item, letter I, the complaint process, we're reminding people of an obligation to respond. People are just kind of ignoring the notices about CPE audits or other complaints, and they do have a legal responsibility to respond to any inquiries that come out of our office. So that is a reminder and will also be incorporated into our CPE ethics course. So our job today is to decide if there are other items that need to be incorporated or added, and then we will make a recommendation to the full board tomorrow about approving this. So does anyone have some questions, or they thought of something that should also be included in our CPE ethics course?
Should we consider something about self-reporting? I mean, I don't know, maybe that's just understood, but, when you've got these rules here, and are we always I would like to think that if they discover have a conflict of interest or whatever, and, after the fact or whatever, that they self-report. That's, to me, part of the integrity of it. If there's something wrong, that they are the ones reporting it rather than a third party coming and telling the board. Or
I feel like something like that, they would have to, you would think if they're willing to self-report, they're willing to go back and fix whatever
right.
conflict of interest they had. So
yeah.
I don't know if they go back and address it. I don't know that they need to report that to us. I don't know. I don't know if I'm making myself clear in that front, but
I don't know if that would be a new rule that would require self-reporting. That would be my other.
Under the last bullet under C, we talk about reporting change. Maybe that's not the right title there. Reporting changes to the board. It's really your reporting requirements, because not only do you report your name, address, email address changes, but you're also required to report discipline by another board or a felony conviction. It's very specific in the rules as to what you have to report to the board. So I can redo that wording a little bit to make sure the discipline, felony, those types of issues are covered well.
Tomorrow, or what? How do we proceed today?
I mean, you could pass it with clarification language, I would think, couldn't you?
So you can approve it provided that we add some emphasis in that section to reporting requirements for items outside of status, meaning address. Or you want me to redo the wording and bring it to tomorrow? Would that be better?
To be sure there's no confusion that if someone has rectified a conflict of interest, I don't think it needs to be reported. That's where I'm going with what I'm saying is, I feel like if somebody's going to self-report, I would certainly hope they would have addressed the conflict of interest that led to them wanting to self-report. Like, they should have fixed that problem and dealt with it.
And I guess I'm not sure there's a requirement to self-report.
That's what I'm saying. I don't.
Yeah.
I want to be careful whatever it is we're putting out there that
right.
somebody realizes they had an independence issue, for example, and they have to go back and say, look, I wasn't independent. We got to return fees or we got to do something. You need to get another audit. To me, they shouldn't have to report because,
No.
and so I don't want people thinking, well, an independence violation, I better self-report because we're going to get inundated if some of that stuff happens.
I'm mainly, when I'm addressing that, some specific instances have come to my mind, and what made me think of it were people that had been caught and, convicted even of things, but they still had not reported to this board, and they still had their CPA license.
Well, that's what this says here. I mean, you got to report discipline and felony. I mean, to me, that should address those concerns.
What I can do is review that rule just to see if we're covering it extensively enough there. But I agree with you. I don't think if you had an issue or you had an independence issue, you would go back and fix it, and you wouldn't be required to self-report that. So I'll see if there's anything we need to add there. But I think in this outline, I mean, TSCPA needs to go back to that rule and then create their content based on the requirements. And then if they have questions, let us know. But I think I recall the situation you're talking about, and that was a true violation. I mean, that person had a felony and needed to report that.
Yes.
Okay, so are we comfortable, because we already include discipline and felony in that particular bullet, are we comfortable with approving this outline as is right now?
What I can do is bring the relevant rule to you tomorrow and see if you feel like the bullet covers the requirements. How's that sound?
Okay.
Recommend approval pending the review of that rule on reporting requirements.
I presume y'all have gone back and looked at the complaints and kind of tallied up kind of our more significant areas.
That's where the conflict of interest came in.
Go that in, yeah. Okay.
Yeah, I felt like we were addressing everything. In fact, I think TSCPA did a really good job this year of addressing the peer review and firm permit issue, even though we continue to see violations. I can't be more black and white than the way they've presented it this year. I mean, so I don't know what more we can do.
The whole goal of this is to limit Kevin's committee's work.
Right.
That is the way I look at this.
Right.
So I think it's good that we've got all that covered.
Yeah.
Motion?
I'll make a motion that we approve these state-specific ethics, the outline for 2020, and tomorrow we'll just review the paragraph or whatever of the rule, just to make sure we've covered everything.
Second?
Second.
All right. We'll take a vote.
Pamela Church.
Aye.
Stephen Eldridge.
Aye.
Greg Gilbert.
Aye.
Gay Moon.
Aye.
Judy Weatherby.
Aye.
Okay, any discussion? All right.
One question. So all those people that present the ethics course, do we approve them or does the society approve them?
We approve them. So in that third bullet,
That was that application comes to
right,
us.
the application comes to us first, and they will not sell or contract or really have a lot of discussion with them until
We
they
approve them.
Right, because when I approve them, I copy TSCPA so that they know they can enter contract with them.
Any professor, anybody out there that's in public practice and wants to teach this content comes through us.
Right.
Okay.
Right. I really feel good that there's not some rogue person out there teaching it. Crossing my fingers, but I think we've got a good process in place.
Probably shouldn't have said that.
I think we've got a good process in place, and both of us are on the same kind of rhythm with that. So,
Okay. We also have 3 individuals, 2 license reinstatements and 1 application for a license that this board staff have asked us to look at. The first one is a new license, and his application was denied as a result of civil proceedings initiated by the SEC. I don't know how to describe this without. So, Maria.
I think, can you turn it over to Maria
Yes.
and she can try to summarize it for you?
Yes.
Yes, so Mr. Wood Schuman applied for a license, and in the statute, it says that it shall be granted to those with good moral character, and good moral character consists of not having a record or a history of dishonest acts. And so his license was denied on those grounds. Mr. Schuman did not receive a criminal conviction, and I think it's very important for the board to not go down that route, because that's not what he was denied his licensure for. These are documents that they're provided to you all from the federal court. And what happened was the SEC made allegations against Mr. Schuman that said he engaged in insider trading. And so the allegations were made, and then Mr. Schuman entered into a settlement agreement with the SEC. And in that settlement agreement, it was noted that he would neither deny or admit the allegations in a public setting. So we considered that to mean that he couldn't come before the board and say all the allegations were not true. So the board can do what they want with that information. It can be confusing, so I'm happy to answer any questions.
Is this the first time this person has, you said it's a first time application, is that right? Well, and there wasn't no CPA before, or what was in another? No. So did he take the exam and just recently? I mean, I'm curious about the timeline of all this.
Yeah, I believe it was recently. Give me a minute and I'll try to find his application.
We're going to get clarification and have a good overview. I believe he is coming in tomorrow, and the debate and discussion will be mostly tomorrow. But this is to help us have a better understanding prior to his visit tomorrow.
Wendy, I know your letter to him was August the 6th of 2019.
Right, so he just applied, yes, this summer. So all of that is new, but I didn't recall if he had passed the exam a number of years ago and was just now applying, or exactly when he had taken the exam. But yes, he just applied this summer.
I had wondered about when he had passed the exam also, because I couldn't figure out how he'd never popped up on the radar before. Does NASPA, does he not have to answer questions before, when he's applying to sit for the exam?
He's never been convicted of a felony.
Well,
Right.
all of the.
So if that's the question, that's no.
But
Right?
all of this happened just this past spring. The actual act happened
13, 14.
13,
Okay.
14, something like that. But the SEC, if I'm correct, Maria, did not hand down their decision until earlier this year, and he had already gone through all of that
Okay.
process.
Can somebody clarify for me? Okay, I know his settlement order, whatever it said, is that he couldn't deny that he had done this, but he didn't have to make it known. If I read that correctly, what is our ability to use this document? I know we don't have any of the evidence or anything like that, or whatever it was. I mean, we're basing this on the fact that he had I guess it'd be a neutral settlement saying he was not innocent nor guilty, but it says he can't deny that he was guilty. How do we use this information for this decision?
So I think that's going to be up to the discretion of the board to look at it and determine if you believe that would constitute a dishonest act, or if you would then decide in your own judgment that this would constitute a record or a history of dishonest acts. The allegations were provided, and if you can't deny those, that's up to, I want to remain neutral and allow you to, yeah.
I Because, I mean, it's a lot of facts, but are they really, truly facts, since it doesn't state he was guilty? Do we just ask him, are you guilty?
You have the freedom, yes, tomorrow to ask him whatever you would like, and I think that might give a better picture. I'm not really sure, so.
So he has to answer that, I guess. I mean, he can't.
He can't
Says
answer.
a refusal to admit the allegations is equivalent to a denial.
It was, when we were analyzing it, we kind of looked at it at the fact that, that's an inference of, I don't want to say guilt because there's not a judgment entered against him that said he was guilty. But that if he can't deny those, then do you want to grant a license to someone who cannot deny insider trading charges against them by the Security Exchange Commission?
We do have some evidence within the document, such as text messages, right?
Yes.
So are we free to evaluate those ourselves in making this decision, even though they did not, there's not a court that has said that he's guilty?
So, again, we're not basing it off of a conviction. So, I mean, I think that's important to note.
Let's talk about the moral character. Do we believe
Exactly.
that the
Is
moral
this a
character
dishonest? Does the board
prevents us from issuing a license?
But we can use these documents as evidence to us. That was my question as I was looking at them.
Yes, you can take that into account in the evaluation of the, of his appeal. And then I think it'd be very important to ask him any questions or concerns that you might have in order to get
But you can't,
a better
he
understanding.
can't tell you whether it's true or not, right? So
One thing as I was reading through it, my thought was he is not above reproach. I mean, there's definitely some question there. And I don't think it's whether guilty or not guilty. It's just there are a lot of facts in there where we can look at ourselves, and whatever decision was reached by the SEC, we don't have to, take that into account. We have enough information to look at it and see if we think he's of good moral character and above reproach and would conduct himself in an ethical manner.
is there a precedent with similar cases?
I've never been presented with an issue. I haven't seen an issue like this specifically for this board. I do want to make a point, though, of clarification. So the consent agreement that he entered into said that he was not denying the allegations were not being proven as true and that there was no, admittance of guilt there. However, also there is a provision that states he is not to deny the allegations in a public statement in accordance with a federal statute that kind of governs SEC settlements. So the part about not admitting, that does not apply to a public statement. The part about admitting applies to for the denial. He cannot deny the allegations. It doesn't say he cannot admit them in a public statement.
Okay.
The settlement says that they're not admitting or denying.
So if we were to ask him if he committed these acts, he should be able to answer affirmatively, or
However, he could just
Free to answer affirmatively or to say no comment, I guess.
Yep. And then the board, based on that information, can do whatever they would like with that.
Okay, that's,
Sorry for the confusion.
I think we're getting overly technical here. I mean,
I think that's
he obviously
important.
profited from a transaction that he shouldn't have profited from. I mean, regardless of whether it was criminal or not, I don't know that really matters in the context of this conversation, because this agreement, like I was just trying to figure out what date this was May of 19 that he entered this agreement, which means it's pretty fresh in the public's eyes to what happened. So I would be concerned about issuing a license, considering whether or not he did it 5 years ago. This is when he received his judgment, or whatever you want to call it. That just gives me pause. I don't know.
I agree with that. He does mention he's extremely limited in what he's allowed to discuss about this case, so,
I'm guessing he won't say anything other than
yeah.
it's in the agreement. I'm a good guy.
Probably not supposed to come down on one side or another right now, right? Don't we need to defer that?
Just based on a previous question, he passed the exam in May of this year. Yeah.
Also, Wendy, can you speak to the question about the precedent? I mean, there's not for initial licensees. We haven't seen an issue like this, but if someone holds a current license and they enter into an SEC settlement, Wendy, didn't you say that?
We typically would open a complaint, and in most cases, we discipline to some degree.
We know what he's doing now.
No, so you can ask him
We can
that
ask
tomorrow.
that tomorrow.
Mm-hmm.
Might be helpful, at least it would to me, to have a paper copy of this information tomorrow. I think you'd mentioned in the email that
That's
we
right,
not have
because
that.
it's not on the iPads.
Because as we ask questions, I think it's important that we
Absolutely.
have the actual.
Yes, I will
facts in
certainly
front
have
of us.
those tomorrow. Mm-hmm. Yep, we have it. Thank you.
One other note on this case, I have to recuse myself from both the voting and the deliberations because one of the entities involved was an audit entity of the firm that I work for, and
Okay, if there are not any more questions on that one, maybe we can go to the next one.
Okay. The next one is Kim Creasy. This is a request for reinstatement. Again, I'm going to let Maria give us the overview. And again, we're not making a decision or a recommendation to the board. We're just getting some clarification and some facts so that tomorrow we'll have a discussion about approval or not approval.
So Kim Creasy, her license is currently expired. She held a license up until 2011, and at that time, there was a complaint open on behalf of the board that stated that she was not up to date on her professional privilege tax, and the investigator who had the report was not able to contact her. So there was some contact information, and they were never able. I'm not sure if Ms. Creasy even knew that this complaint was opened against her. And since then, she has applied for reinstatement. We have confirmation that she has paid all her professional privilege tax. She's up to date on her CPE, and so just in order to move forward, we wanted to make sure the board was okay I don't want to influence your decision. So whatever you all would like to do on this application, you can grant the reinstatement. You could reopen the complaint. You could deny it altogether. But it's important to note that she's done everything she's supposed to do, and she'll be here tomorrow to answer any questions you all may have.
I'd like to clarify that she has not paid the professional privilege tax. It's been so long that the Department of Revenue had written it off. And so to them, she does have a zero account balance, and they would not take her money at this point, but she did not pay that previous.
Oh, okay.
Wendy, what is when we get notified by the Department of Revenue, or when we find out that someone's been delinquent, what has been our historical protocol on that?
So in maybe 2016, the Department of Revenue began feeding us data, and it was inputted in our system, so there was an automatic, what do we call that? Hold put on their license, so they couldn't renew if they were delinquent on their professional privilege tax. Prior to that, which is Ms. Creasy's situation, the board staff wouldn't know till much later than the delinquency, and then complaints were opened for each one that they determined was delinquent. And so that's where Ms. Creasy is the staff at that time was notified that she was delinquent, and so they opened complaints instead of holding renewals. It's just not the way it was handled at that time. At this point, we hold renewals and we don't let you renew. Of course, that goes away.
Is this individual coming tomorrow?
Yes.
Okay. Just curious. She's asking for reinstatement after so long.
I believe verbally she told Karen that she was wanting to reciprocate to North Carolina, and she needs to bring this one active to reciprocate to North Carolina. I'm not sure if she currently lives there or she's moving there or.
She doesn't have an active license anywhere, does she?
No, but she can't apply for a new license in North Carolina
until this is cleared up.
Right. So they'll tell her she needs to come here and get her license active.
Based on what you said earlier, given the systems and the length of time since the delinquency and the write-off by the state, I think I heard you basically say she couldn't pay it today if she wanted to.
Correct.
I mean, it's just not, they would not accept it.
Yeah.
Is that right?
That's showing a zero balance for her after the write-off. And yeah, they consider her in good standing right now.
Well, there is no professional privilege.
Right.
So it's like
true.
For certain professions.
Yeah, true.
Easy now.
Any other questions or anything on Ms. Creasy? Okay. Then we'll move on to the third and last person that is requesting a reinstatement of the licensing. That's Tracy Wright. She has some history here, and I'll let Maria go over her story.
Yes, so Tracy Wright, I think it'll be important to keep in mind that we're not deliberating on whether or not we're reinstating this application today or tomorrow. Ms. Wright will be at the January 2020 meeting. If the board deems that her application is complete and ready for review. According to our records, she has everything that she needs in order to request a reinstatement. She's currently in revoked or suspended? Revoked status right now. And so the purpose of this review of her application and her standing is just to determine if she can come before the board to request the reinstatement in January.
So is she, okay. Has she done her CPE requirement?
So, upon further review of that section of the rules, I don't know if you all have that handy, but the reinstatement of a suspended or revoked license does not require CPE up front. Suspended would, because it's a part of when you have a suspended license, you still have to obtain your CPE and attest to that at renewal. So I believe the purpose of that is once she comes before you in January, you have a lot of options. You could not give the license. You could give the license with restrictions. Stop me, legal, if I'm incorrect. But so at that point, you could say, well, we agree to give you your license back provided you obtain 80 hours of continuing education. And then once she submitted that, we would give the license back. I think it helps everyone out to not have someone have to get 80 hours of continuing education for then you to deny that license. And so, again, you have numerous options in January. You could
will not be here tomorrow.
Not tomorrow. So it's just a chance for you. The rules say that we have to, I don't have it right in front of me, but the rules say it's in 2-meeting process. You present the application at the next meeting for presentation and evaluation at the following meeting. So it's always been a 2-meeting process on a revoked or suspended license.
Have y'all had conversations with her? I mean, I guess you've talked to her a little bit.
It's all been written. Mainly letter.
I mean, there's just such a pattern of disregard for the rules here, which is concerning.
And I think one of the things that we had, Stuart stopped me, or Maria stopped me, but we have 3 open disciplinary matters concerning her right now. And with a revoked license. So we could have a hearing and we could go through those And
Well, I mean, this might seem odd to all of you that, you do want to jump and evaluate and look at that kind of thing. But the rule is very clear that the application shall be submitted to the board at its next meeting and evaluated and reviewed for presentation at the following meeting. So I think it's important maybe just to focus on the application to see if you would at least like to hear Ms. Wright and see if it meets just the requirements to get her here for January. And then at that time, that's whenever we can maybe flesh out some more of the historical concerns that we might have.
For the record, I'll be recusing myself and abstaining from any of the issues on this particular person. I will not be speaking or participating in or the January portion of that.
Remind me again, we're looking at the application this meeting so that then she can appear. So we say we got a properly filled out application. Is that what you're saying?
Completed the application. She's paid the fee. She's done what we've asked her to do. From an application standpoint, yes.
So is her comment on explanation of item C, it says, in 2014, a complaint was filed by the Knoxville Zoo for practicing without a license, and the complaint was dropped. No disciplinary action was taken. Is that correct?
I have a complaint for that. In that box up there, it says complaint number 20140168001.
I don't have that right in front of me. What does it say the resolution of that was?
Don't know that I forgot the resolution.
Okay, I thought it was listed in that timeline.
But we're not considering these issues.
Yeah, you're not considering that.
Okay, even though that's part of this application.
It's part of the application. She's just explaining why she's coming back to reapply.
Okay.
And that's all you can take into account is the actual application and make sure the requirements are met. And then in January, that's when you can.
All right.
It's just part of the rule.
Other discussion.
So we're just acknowledging that we received the application?
That's it.
I mean,
basically, yes.
Okay. And whether or not we would allow her to come back in January.
We can make the decision on whether we would allow her to come back and apply? Or
Well, you would base it off of, are the requirements met for the reapplication?
She's just applying at this point.
So when we decide we need to ignore the history
that even she provided?
I mean,
Yes.
okay.
So she has to provide that. It's in the rule that she has to provide that information. So if she's providing information, she's met that requirement. If she's filled it out completely, she's met that requirement. That's all you're looking at.
Step one of like 5,
Okay.
I guess.
So January would be when we take into consideration the history and, okay.
Will she be present in January? Or
She will be present in January. She will not be here tomorrow.
Hey.
Or she may be here.
Yeah, I don't even know.
She's supposed to come. It's a free country.
Other discussions about that? All right, I think that concludes the licensing.
Exciting committee this time.
Thank you, guys. I think what we'll do is we'll try to work through enforcement here, and we do have a kind of a lengthy list of cases to go through. Andy Bonner will be assuming the chairperson role of that committee, but in his absence today, I'm going to go ahead and continue on in the role that I had previously, in kind of in an ex officio capacity. So the first item we have is just an information item on the complaint statistics. We've got the complaints open and closed by months in the report. along with the quarterly numbers and comparisons to fiscal years going back to 2015. And then a listing of the open complaints as of October 15th. And so that's really an informational item, not any decisions or actions to be taken on that, but it gives us a bit of a status check. Our open complaints are creeping up a little bit, but that's not really uncommon, in part because this was the quarter where a lot of CPE audit activity would have hit. Questions for Wendy or staff on the complaint statistic section? We'll go ahead and proceed to the underlying cases that will be the subject of action formally by the board tomorrow. We've got kind of the two-page summary of the cases. We have 27 of them, but many of them are falling in the category of the CPE requirements, and so there'll be letters of warning proposed for those. And we'll just start going through them, beginning with the first cases and just proceeding down through the list.
I appreciate the summary. I don't know the first time. That makes it nice to kind of look at.
So,
Very good.
Very good idea.
But we thought it might be a little bit helpful, especially when we have a large kind of docket as we do here. And we'll try to keep that going as well. And any other suggestions on how to make this more useful for anybody, just let me know or let Wendy know, ideally. So we'll go ahead and begin. The first 13 items are the consent items, and so what I'll do is just briefly synopsize them, and then we'll ask from the committee for a recommendation for those items in total to proceed to the board, unless there's one that we want to pull out, and we can certainly deal with that as well. So with respect to case number one, we've got a case that is involving due professional care and failure to furnish records upon request. This was investigated. Staff's recommendation was to close the case because there was not enough evidence to support the underlying allegations of the complainant. Item number two, broad category, was integrity and objectivity and confidentiality. This is one where we have a situation where a divorce case is involved and there's an expert witness, and the complaint is with respect to that activity. The underlying case is still in process, and there's likely going to be litigation that's arising from this case on the part of the complainant. And typically in that type of a setting, we take no action. We place it in monitoring status, and that's what's being proposed here. Case number three, we have, this is a case involving discipline from another board. However, that person is not licensed in Tennessee, so there's really no formal action for us to take, and we're proceeding with the staff recommendation of letter of caution on that one because the respondent is not licensed in Tennessee. So there's nothing really for us to do on that one. Case number four, this is one where we have an unauthorized use of a CPA designation. And in this particular case, it was an anonymous complaint. We followed up with the respondent. And the respondent basically had a license in inactive status. And there was a bio that was being used by the respondent's employer's website that did use the CPA designation at the time that the complaint was filed. So it was out there. And there was one other CPA designation on a press release that was out there that had been put out by the respondent's employer, also identifying that person as a CPA. There was no reference as a CPA on the social media or business card, and the respondent has not performed any attest services in the state of Tennessee. He has been employed in private industry. So in this particular case, as soon as the respondent was contacted, he immediately removed the designation upon receipt of the complaint and acted promptly with respect to that. So the recommendation here will be for a letter of warning due to the mitigating factors of it. He was clearly not trying to hold himself out, and as soon as he became aware of the elements of the complaint, he resolved them. Case number 5 is a CPE case, failure to perform CPE. However, that respondent has passed away, and so the recommendation is to close it. Case number 6 is a situation where the respondent was the complainant's accounting firm for several separate franchised entities, and a complaint was made on a number of fronts, and the respondent denies those allegations. The engagement was terminated, and the respondent has filed a lawsuit against the respondent has filed a lawsuit for recovery of unpaid invoices. There's still litigation going on with respect to this whole action, and so we typically place it in litigation monitoring until it resolves itself, and then we determine whether to proceed.
Kevin,
Yes.
who embezzled? Allowing a partner to embezzle.
That was a claim.
So the complainant,
Or who are they claiming embezzled?
Sounds like somebody with the complainant.
That
maybe.
just seemed like, there's a list, and that's a pretty big
Yeah.
deal. But I didn't even know exactly who they meant.
yeah, the way that I read that, and maybe Wendy or legal can chime in, is that they were apparently embezzlement occurred, and he was basically in part including a complaint against the
Blaming the
respondent for
respondent.
it happening on that person's
On his
watch.
Okay.
So the recommendation there is litigation monitoring on that one. And then with respect to case number 8, this is a case, 7, excuse me, I passed by that one. Here we have a case of it's basically a billing dispute. So we have a case of charge for services not rendered. Typically in a billing dispute, the board does not take jurisdiction, nor does it attempt to resolve those kinds of disputes, and so the recommendation is that would be closed. Then case number 8 is really basically the respondent or the complainant argues that the respondent did not get tax work done in time. The respondent did file an extension. The complainant alleged that the respondent was not returning calls or emails, and basically there's some back and forth there, and the respondent ultimately did file the tax returns once that respondent got the transcripts from the IRS that gave that person enough information to file the returns. So the recommendation here is to close it because there's not enough substantiation for a legitimate complaint in this case. Items 9 through 13 are all failures to satisfy CPE requirements. And in essence, these are resulting from CPE audits that were done during the period for the last review period. And in those audits, there were deficiencies that were found. In some cases, I think in all of these cases where the result is a letter of warning, they were given time and penalty hours to follow through on their CPE, get the makeup CPE credit done, get the penalty hours done, and they have completed that work. So they have done what the board has asked them to do through staff. And so the recommendations for each of these will be to issue a letter of warning. They've already effectively been penalized because they've done the penalty hours for being delinquent to the regular meeting their requirements for the gap that they had. Let's kind of stop there. These are the 13 items on the consent agenda. Are there any questions, further information that would be requested here for any of these cases? I'll entertain a motion to recommend to the board for approval tomorrow the disciplinary recommendations that are as listed in cases 1 through 13 on the consent items.
So moved.
We have a motion from Janet. Thank you. Is there a second? Second. Second from Todd. Thank you. Any further comment or discussion? Not, we'll go ahead and call the roll.
Janet Booker Davis.
Aye.
Pamela Church.
Aye.
Larry Eldmore.
Aye.
Kevin Monroe.
Aye.
Todd Skelton.
Aye.
Okay. We will go ahead and proceed then to the series of cases that are proposed discipline, and then separately we'll deal with the last tranche, which are representations. In what distinguishes these from the consent agenda typically are there is likely going to be a consent order or some discipline that's actually imposed beyond a letter of warning here, and so we'll deal with each of these, and we will vote on them as a group or pull out any that need to be pulled out once we get through all the proposed discipline cases. So beginning in case number 14, the synopsis here is that there was a complaint filed by Tennessee Department of Revenue's Special Investigation Team. It was determined that there was a falsified sales and use tax return that was filed with TDOR. I won't go into all the details of the case, but the TDOR pursued a criminal case against the respondent in cooperation with the district attorney's office. The respondent did enter into a guilty plea and received a 1-year sentence of supervised probation with sentencing deferred. He did not deny the allocations of the complaint in his response to the board's complaint, but he basically is saying that the negotiated settlement with the TDOR is not a conviction of a felony. He does not provide any extenuating circumstances surrounding his actions and does not provide any explanation for his actions. So the board staff has recommend authorization of a hearing with the authority to settle via consent order upon the respondent's payment of a civil penalty in the amount of $2,000 for fiscal dishonesty and failure to report the filing of a report required by federal or state law, and also a recommendation to complete the 3-part NASBA ethics course within 30 days. His license will be put on probation for the duration of his deferred sentence with respect to the TDOR case. And since he's also licensed in Texas, there would also be a disciplinary action referral to that jurisdiction. Any comments or questions on that one?
I'm curious if that's severe enough. I mean, I just want to open that can of worms. I mean, he willfully provided a document to state government that was fraudulent. And so that's, in my mind, it's not that he just didn't report it. It's the fact that he willfully provided a false document to to our state government, essentially. So that, to me, is pretty severe. I don't know, and he gives really no explanation or anything surrounding the whole issue, right? It's just kind of, here it is, this is what happened. And so, I don't know. I'd kind of like to hear from the guy, honestly, as to why he thinks this is not rising to a level beyond a penalty. I just feel like a penalty is a slap on the wrist, but all this to save $9,000 of tax. I mean, he's buying a $128,000 airplane. Y'all may not feel that way. I'm just throwing that out there.
Fair point. So, other discussion?
That was my impression as well. This is huge.
Willfully doctoring a document to provide to state government to avoid $9,000 of sales tax.
Directly related to the profession.
That's correct.
So this might be just a good time while we're on this particular case, and given the kind of the general views, I think, of the members of the committee, in terms of the range of disciplinary actions that would be available to the board in this particular case, let's kind of just talk through what that range is beyond the civil penalty.
I assume we can suspend his license, right?
That would be within our purview to do that.
This just kind of flies in the face of state government trying to do what they do. And when a member of our profession directly lies to them, that's a pretty big stain, I think, on our profession if we allow this to go through with just a $2,000 penalty.
A higher range of penalty as well?
Well, that was the whole point of the 2,000 was the 1,000 for dishonesty and the 1,000 for willfully lying. So that was because your penalty is 0 to 1,000 max.
Per day of violation.
And per day. But
it's got limits in theory of penalty. I'm not so concerned about the penalty of that as much as I am of doing something to the license just because.
Oh, no, I'm not disagreeing with that either. I was just wondering about the amount of the penalty.
We've already said today that we do not allow people to apply if there was evidence of dishonesty, a character problem. This is huge. I mean, to me, this is in the same vein.
So, given that discussion, would
I'm not on the committee, so I'm just.
That's okay.
Larry, speak up.
We value that input regardless, but it sounds like from those who are on the committee, there's a consensus to pursue a disciplinary outcome here that would be greater than the $2,000 civil penalty that's currently recommended. And although Trey's not on the committee, he will have a vote tomorrow. One of the options is to suspend a hearing. Is there a thought of doing that, at least suspend until we can have the formal hearing?
Does it have to be a formal hearing, or can we suspend it pending his ability to show up and discuss why the license should be?
We would send a proposal for him to voluntarily suspend his license. And if he doesn't agree,
formal action
then
first,
if he doesn't agree, then we would do a formal hearing.
Okay.
To specify a suspension date or period in connection with that correspondence?
Yes. You would have to have some kind of date until that he wouldn't be suspended.
Stuart, our rules don't talk about any automatic lifting of suspension, but if you stated a time frame, then that would be his time frame in which he could come back and request the license back.
Yes.
Okay.
Yeah.
You know when the guilty plea was entered?
Oh no, that's when he bought it of 18. So,
well, I don't believe it was an actual guilty plea. It was some kind of agreement, but
It's some type of deferred prosecution.
Settlement, but then he was placed on probation.
He was placed on, he's placed on probation.
It says guilty plea is why I'd use that, but I assume it's some type of
I
deferred
believe it's on
prosecution.
deferment.
The DOR announcement's June of 19. I'm trying to go through my files to see if I can find something else, but it's been.
Is this person actively practicing in public accounting, or what does this individual do? Do we know?
Offering consulting services.
It's not something he would necessarily need his license to do.
No, he is represented to us that he's not doing any test services. It's mainly management consultant. This person was not in a firm or practicing in a firm.
But this this was a tax return, like Trey was saying, which he actually falsified something that CPAs do for a living. So it's not like he filled out an application wrong, or he, was looking.
It was willful. I mean, that's the way I look at it.
But suspending his license wouldn't impact him on tax.
But my point is that may make him show up and explain why he chose to do this.
I agree with Trey. I think what we have here is not severe enough, and I think it almost. I mean, if it were a income tax return, say it was a sales tax return, but a sales tax return is just as important as any other return that we prepare. So.
I just want to make one point of clarification. When I was looking at this individual's sentencing from the court, he never received a guilty conviction. He's under probation right now, and pending that he completes his probation without any further offense, this judgment is going to be deferred. And just under the statute for deferred judgments, and we couldn't consider that. The board couldn't consider that. So that's why I think we went the route of the fiscal dishonesty.
Can't consider that he pled guilty?
He pled guilty, but the judge did not find him guilty.
There's no denying the statement of facts that occurred. Whether or not there's a conviction or not does not preclude us from imposing a restriction on his license. Is the way I view it.
What he said I mean, if you look at the two numbers, you're up to two from the
That's-
one on the
I
other
know.
side.
I know, I kept looking to see, could this possibly be a mistake?
Yeah.
But I don't.
A little white out involved.
Well, it also said he was evasive when questioned, and, he did not come back and say, oh, it was a mistake.
I don't know if we can put him in suspended status until he appears before this board, at which time we'll make a decision as to what to do. You can't do that. No. Ask him to voluntarily do that.
I'd like to see it would be more important to do that, but
Right.
since he's not, I think
I would revoke his license.
Voluntary revocation, or he comes before us in a hearing?
I think it's that level. I really do.
well, especially with the size of the dollar.
Right.
I mean, if
Well, really, compared to the airplane, it's not that much. I mean, if you're buying $120,000, you're saving $7,000 of tax. I mean, I just don't understand that.
So maybe just kind of to throw something out there for purposes of discussion in terms of the revising the recommendation via the committee for consideration by the board tomorrow. Right now, the current recommendation as it stands does indicate that his license should be put on probation for the remainder of the deferred sentence. But in this particular case, I guess the consensus that I'm getting is that we would proceed to recommend, a revocation proceeding with respect to this person and, with a formal hearing to follow. Is that
Don't have any problems with that?
We're going to do whatever y'all want to do.
I'm just curious. I've been told no before, so. Yeah.
What does it mean to put the license on probation rather than to it means to revoke it, but to put it on probation, what exactly does that mean?
Well, I mean, mostly, I guess sometimes when we put it on probation, it just means if you do something while it's on probation, then it'd be like an automatic revocation.
Okay.
You still have the right to practice.
So they
when
they
you're-
still
They can
Okay.
still practice,
Okay.
but you can put terms in there. You have that discretion.
I guess what I would propose, just to kind of clarify here, would be the proposed disciplinary recommendation would be to authorize a formal hearing with respect to the revocation of the respondent's license.
Yeah, you would authorize to propose a consent order for voluntary revocation and authorize a formal hearing if they decide not to agree.
Okay. Given that, is there still, would there be consensus among the committee members to retain the $2,000 civil penalty? I think we'll also include the $2,000 civil penalty as part of that as well. All right, any other discussion or questions on case number 14?
$1,000 seems kind of small compared to what we're proposing to do, but
Is that in line with, other similar types of?
It's in line with the rule from 0 to 1,000 for each. I mean, you can do it for each day, but that was for each violation. And that was the dishonesty and the willfulness to lie about the sales tax.
I don't think historically we've
Well, yeah, I was
compounded
trying to
penalties by
understand.
day.
I must say, this is the first.
I mean, I don't disagree with Mr. Elmore. I could be sold on any penalty level on that front. I
don't know what the magic number would be, but compared to what we're talking about doing, it just seems small, but I don't
So we don't typically, not to say we haven't, because we have done this, but we don't typically, if you're going to recommend revocation or voluntary revocation, a lot of times we don't add the civil penalty because the benefit, or I mean, not the benefit, but the licensee, it's like, well, if I'm revoked, why do I also have to pay you money? We have done it, so it's not, but
You may not care if it gets revoked. And therefore, there's
That's
a
his
penalty
need
attached
anyway,
that follows
yeah.
him, right? That 2,000 could be enforced against him at some point.
Through collections.
Correct.
Yeah. Yeah. So it's not that you can't do it, but a lot of times if we're doing revocation, we just don't add anything else. But
I think in this case, I'm at least comfortable with imposing that because he's apparently not doing a test work and he could continue doing what he's doing without
Right.
a CPA license at all.
And there would be no penalty, essentially.
What about 5,000?
I'm just concerned because in our kind of range, our policy guidance would imply 0
Yeah,
to
that's what I was
1,000.
trying to get to
So-
before, but it's.
I don't know. This is fraud. I think you could do. I don't know that you're limited in this situation. I just.
You're limited to each violation,
But
per day.
So I can
Per
go.
day.
I mean,
But
I
you
can
have to
impose any
prove, you have to
penalty.
prove what the 5,000
What it is
means.
for.
Yeah. Was it because it was Monday through Friday, or I mean,
$2,500 for each violation.
up to 1,000?
Oh, that's the max.
That's the max. Yes.
Per day.
Per day. Is it per day? 1,000 per day?
I would argue that the revocation will affect him just as far as a professional record. If you're hiring a management consultant, I don't think you'd prefer one with a revoked license.
But if he already has a reputation and he just drops the CPA, then does it really? I don't know. Doesn't seem overly remorseful, and that's not.
I'm not on the committee, but I'm telling you, if he falsified a sales tax return, and then he will also probably keep that CPA right behind his name. I mean, I think we should probably follow up on that sort of thing. I mean, there's a history of dishonesty there, a willful dishonest. So.
I would counsel that we stick at 2 and revocation, as Stuart laid out, consent order for voluntary revocation, and then a hearing if he wants to contest that. All right, thanks for the robust input on that one. We'll go on to item number 15. The synopsis on this one is the person, the respondent, basically, let me make sure I'm on the right one here. Okay, yeah, so in this particular case, the complaint was filed by the board against the respondent firm upon notification from the Tennessee Comptroller's Office that the firm could no longer contract for audits under their jurisdiction. And so typically when we have a situation where we have another agency or entity that has concern about the quality of the work performed, we'll open that complaint. And in this particular case, the staff has determined that there was a violation of multiple Tennessee accountancy rules. So the authorization here is to authorize a formal hearing with the authority to settle via consent order upon the payment of a civil penalty in the amount of $1,000 and the placement of the individual license and firm license of the person and firm on probation, which would be lifted only when an accepted peer review with a rating of pass is submitted. The person's also licensed in other states, Mississippi and Texas, and they would be referred as well based on this situation, which we would typically do. Any comments or questions on this one?
This individual's never come before this board before, is that? Okay.
On to number 16. 16, we have an unlicensed activity case. We became aware of this on the basis of the application for the firm permit and discovered that one of the owners in that application held a revoked license. It was revoked back in July, just earlier this year, for failure to comply with the previous consent order by not paying the $3,000 civil penalty that was assessed. The respondent indicates they're in the process of opening a location in Germantown and have not yet performed services out of that office. But as of October 16th, despite notification, the firm's website, including the firm name with the CPA designation for the Germantown location, which does not have a firm permit and has not been licensed, is still up. So the respondent was notified that they're entitled to request an appearance before the board to reconsider the application denial at its next meeting. That was sent in August. The person did not appeal that request. So the recommendation is to authorize a formal hearing with the authority to settle via consent order upon the respondent's payment of a civil penalty in the amount of $1,000 for holding out as a CPA firm without proper licensure. And this is, I guess, to highlight, licensure is required by location. So it's, if you're a firm and you have multiple locations, you have to get a firm permit for each location. Really the application of the rule here. And they did not do that. They were informed of it, and they still have not taken down their website reference to the CPA designation. Comments or discussion on the recommendation or the facts on case number 16?
Does the fact that this owner's license has been revoked affect their license for the other location?
I don't think so, does it? Because you can have a non-CPA owner in a firm, right?
Yes, but a CPA firm permit cannot a firm that has a revoked license.
That's just the rule, is that we don't issue permits.
They can keep operating with the same setup. You just like a discrepancy.
Well, the next time they file for their permit, I would assume that would be
it would not
revoked.
be renewed because they would be one of the owners would have a revoked license.
I guess my question is this individual not responding to the board?
I would say yes, we're having trouble with.
That's how I'm reading it. I'm just confirming that.
Odd to let them keep operating
Would think
when
the
they
other
did
partners
this
would be
and
upset.
there's a revoked license. That just seems quite serious.
Have we talked? I'm just curious, and I don't know if we can. Can you talk to the firm itself? Well, I mean, you have already denied it. I assume you're talking to their managing partner or somebody, right? And have y'all said, look, you got to get this cleared up before we can issue a permit?
No, I mean, they didn't respond to the denial, and there have been additional complaints opened
By us or other people?
by us.
Well, this is.
But in this, help me, legal, if I'm wrong, but I mean, although we'd be assessing this discipline, it would also basically say in there, you need to start immediately complying with the law and rules, which would say, you need to take this down. You need to stop doing this.
Right. Well, they're not going to be able to operate pretty soon.
Right.
At this point, the board staff has denied the firm permit.
Correct.
So they don't have that going for this location at least. I guess the question I would have, if there are other locations that are currently operating under a firm permit that is active, are those potentially subject to being affected by this action?
I would think when they come up for renewal, you could not renew it.
But I don't know that means it's affected by this, because let's say we did nothing to this group. There's still an owner of this practice with multiple offices that has a revoked license.
Would a severe action assist staff in communicating with this firm?
I don't know that anything more severe. I think we're going to have to show up on their doorstep.
Are we allowed to revoke a permit for?
There is no permit here.
Well, I'm saying for the existing firm.
Mm-hmm. One of them is revoked, and they're continuing to practice.
You mean the firm permit?
Right. So there are 3 total offices. This apparently was a new office that they were trying to open in the Memphis area.
Are the other 2 in Tennessee?
Yeah.
We're allowing them to operate as usual when they did something that sounds pretty.
So help, legal, can you help? I mean, once we revoke something, they shouldn't be practicing, but people do it anyway, and it becomes very difficult. We're not police officers.
Right.
But we now know.
They are revoked, and apparently they are still operating. And I believe there's some other complaints coming in to revoke the firms. So eventually, everything's going to be revoked. But to be able to go and shut them down, I don't know if we have that authority.
So, but once they move into revoked status or whatever, when they can't renew it,
it's more of a criminal action.
That's statutory that's causing that problem.
It's more of a criminal action, which we would not have authority over that.
What are we supposed to do here?
We make a referral to.
We would make a referral to the DA, local DA.
Okay. Have we made a referral on the current situation where they're practicing on a revoked status in whatever office that is?
No, the revocation happened in July, and we have just opened 2 more complaints to try to get their attention. And if they don't respond to that, we may go down this referral to the DA route.
There's really not much we can do at this point. Is that?
We'll have to comply with a revocation order.
Right.
And when they don't, we don't have authority as the police to walk in and.
How soon will the other offices all be shut down? Do we know?
One is already revoked, but still operating.
Shut down, but operating under unlicensed activity.
Well, the new complaints will be probably presented in January.
No, but I'm saying they've got a timeline to renew their firm permit, which we will not renew.
Right. So they would all be, I guess, expired at the end of the year.
Of this year.
Mm-hmm.
So really anything we do now is kind of ineffective, right? Yes.
Yeah, I mean,
they don't have a permit.
They should never be
That's right.
For this complaint. They should have already taken it off their website. They should not be practicing. They never had a firm permit, so they shouldn't be doing this.
You know what type of work this firm does? Just out of curiosity, are they doing audits? Or what are they doing?
They were at one time.
I was going to say they primarily do tax work, but what had happened that created all of this, we had discipline and then revocation because of failure to address the consent order. But the original thing that kicked this off was the fact that there was a review done without enrollment and peer review.
But it reminded me, as long as they're not providing a test services, they do not have to have a firm permit. Is that correct?
But they're using the CPA in their firm name.
That's the issue.
Yeah, that's another issue.
So they could probably resolve this situation if they would remove CPA everywhere.
Off that one guy.
Mm-hmm.
Which makes this even worse.
Yeah.
Permit really isn't an issue for them. I mean, it should just be not.
Odd if they've chosen not to do a test work, but I feel like I would need to check, but I thought they complied with the peer review aspect of it, so they may be.
Providing compensations or something.
But yeah, they did enroll in peer review.
So if we know that they're operating on a revoked license and we don't go ahead and refer them to the DA's office now, problem for the future? Or do you see any issue with that legally? Such that it would come back on us saying, well, why did you let us continue to operate? You knew the license was revoked.
I think I would probably maybe amend this recommendation. I guess we could go ahead and refer this and the other cases
Sooner rather than later.
to the local DA. However, I don't know if the DA will accept it if they still have, a permit out there on the two. I think it would be better if we had all firm permits revoked and licenses revoked.
Which we could do that in January. Because
Yes.
about the end of the year, statutorily, they should not be renewed, right?
Right.
Can I ask a question of the society regarding peer review? Just as a, sorry to bring y'all into this. You look like you're having a nice time back there. I felt like. So if a firm is operating without licensure, did they get removed from the peer review program, or how does that work?
Let me think about this. And if they're enrolled in the program, I don't know that we've ever had an instance. Nothing comes to mind where we have a firm that's voluntarily enrolled in the peer review program and doesn't have a firm permit.
They're not licensed in the state of Tennessee at this point, right? When this happened.
And we would find out at the time of enrollment because we send firms that are enrolled to the board. So I'm assuming that you all go through some comparison process to ensure.
But if they're not licensed, would y'all kick them out of the program?
My gut says yes, but I don't have a process or a precedent for that of how we would be notified of that and how that process would work. I mean, they would have to go through a hearing process. It's not just as simple as we, as the administrator of the peer review program, can kick somebody out.
My question is that if we referred this firm over to the society, what do you think you'd do with it?
Would have certain questions that we would go to the firm and ask. Through the peer review process, their peer reviewer should be looking at their firm permit, so it should fall out in that peer review process.
Find out when their next peer review is, or if they're...
We can ask them, so if they will tell us, then we'll find out, but with
this whole new open... we're doing.
We're getting there, but we don't have access to due dates yet. So
society willing to share that info with us? They can't.
They're prohibited from doing that.
Now, you all can ask the firm, and the firm can provide that information.
When you have firms that are...
I'm just wondering if the society would have better luck getting them to react if there was the threat of being removed from peer review, is my point. If that inhibited their ability to perform that, I mean, they're already operating under no license. I just think it's one more thing. It's another pressure point.
Were to come to light through the peer review process that a firm was not operating on a valid firm permit, I mean, that would be a process that I believe would be referred to the AICPA Professional Ethics Division. It would not be something that would reside with us in Tennessee as the administrator. And
I do think, though,
for that.
I mean, obviously it's been a few years since I've been involved, but it used to be that if it was determined that you didn't have a proper license when you issued X number of test engagements, then those were considered not in conformity with standards, and of course then that leads ultimately to not a past peer review. But
we refer them to ethics?
We don't refer them.
We don't refer.
No. Well, if we discipline, if this sorts out into discipline, we report discipline to a variety of entities, including TSCPA and AICPA ethics, yes.
We got an unlicensed firm potentially issuing a test engagements out there, and I feel like my hands are tied. There's nothing we can do.
So on the revocations that occurred back in July, those were recently reported out to those entities.
And the revocations of the licenses were reported out to what entities?
So we regularly, when we report discipline each month, we regularly report that discipline to the IRS, the AICPA, TSCPA, the Comptroller's Office, so that they're aware, and if they choose to do something, they choose to do something. If not, they don't.
And so just so I'm clear, their license, at least one license, is revoked in Tennessee. The firm permit.
There are 3 firm locations.
Okay.
One, and the owner is revoked. One firm location is revoked, and the source of this complaint is apparently a new location that was never permitted.
Some of these revocations are in Tennessee.
Oh, they're all, yes.
Okay, they're all in Tennessee.
Mm-hmm.
And our next course of action would be to report to the DA, next option that we have.
Once we after the complaints in January are presented.
No, I mean like now. If they're operating now on revoked licenses, and we know that, and the only other option that we have is to report it to the DA, and you're saying we're not going to do that. We're going to wait till later.
I think what I heard was you believe that there's a stronger case once all of the firm permits are revoked or expired to make the referral to the DA, and you anticipate that that will happen by our January meeting.
2 months from now.
Yes.
I hear what you're saying. I do think you're right.
I believe it should be reported now because their license is revoked. They're not doing work in accordance with standards. That's my belief. And now the DA could decide what they decide, true enough, but we need to do what we need to do.
Enrolled agent or anything like that to sign a return. I'm not a tax guy. But.
All right, so I guess what I would offer up for purposes of proceeding on this one is to it would be helpful for legal to go ahead and pursue with the DA in question, whatever jurisdiction that DA belongs, whether or not that DA believes that the case is strengthened, by waiting until all firm permits are expired, or is willing to proceed based on what we now know. And then we can make a decision whether or not we'll refer. We may not find that out by tomorrow morning when we're asked to act on this, but at least by January, we'll know, that all of their firm permits are shut down or non-operative. And then we're going to strongly push a referral to the DA, whatever that jurisdiction is.
Yes.
I don't know really what else, to do to make the strongest case to get these people off the streets, holding out as CPAs. What I would suggest is why don't we take
a quick
Todd?
clarification before we move to the next matter. 3 offices listed on the website. One of them is an application that was denied. The write-up doesn't indicate it, but is one of the other 3 in revocation status as well, plus an owner in revocation status? Okay. Thanks.
All right, so, with respect to the recommendation, I'm not sure in this case that another formal hearing and a civil penalty are going to be terribly relevant since we're going after him with the DA. So I would almost recommend that we defer action on this until our January meeting.
I think that's more appropriate if it's okay with legal.
Can I make a recommendation?
Yes.
Maybe place this in monitoring status and then let us investigate.
Y'all are continuing to try to reach out to these individuals. Is that correct? Who does? Is that you?
Yes, I do the reaching out. There is one firm location that still has an active permit. And we just filed a complaint and sent it out for response for that individual. So yes, that's what we're referring to it getting into the January pipeline. At that point, I will have reached out to them if they have not reached out to us.
Last question, and I'll gladly let you finish the conversation. Are these offices in the same general area, or are they all across the state?
Great question. This one is in West Tennessee. The other 2 are in Middle Tennessee.
Can we? I don't know if you've done this. I'm just asking. Have you shown up at their door?
I've shown up at the Middle Tennessee location stores. Okay. So, and there's signage out there that still shows the CPA designation.
But the question is, do you ask to speak with the managing partner, or do you ask to speak with whoever's in charge? Or?
I have not recently.
And that's part of the recommendation, place in monitoring status, so then I can...
You can actually send it out for
I can request the investigation. Yeah, I can request it.
I think that's a good idea.
Sounds like there's consensus on this one for case number 16 to revise the recommendation to place in monitoring status with further determination to be presented at the January board meeting. Why don't we go ahead and take a 10-minute break? I'm showing about 2:40, so let's try to reconvene around 2:50.
Yeah, he did. Yeah. Only about 100 items on here.
Well, they were.
Of the Enforcement Committee series of cases. Stephen, are you still with us?
I'm here.
Okay, thank you for patiently hanging in there, Stephen. Appreciate that, and also appreciate the good input from the board members on these cases. I think the next batch of the remaining cases in the proposed disciplines are typically more conventional and normal and similar to what we've seen before, but we'll go through each one here and work through them. Beginning with case number 17, we've got an anonymous complaint filed about the respondent operating without a permit at a newly opened office. However, in this case, they were unaware that they needed a permit for that newly opened office, and as soon as they were informed of that, they cooperated and immediately obtained a new firm permit for that location. So the recommendation is basically for the authorization of a hearing or ability to settle via consent order upon payment of a civil penalty for $500.
Just a question on that is, do we ever issue letter of warnings in those situations? This firm was cooperative, didn't realize it. I mean, yes, they should know the rules, but it's almost like, do we really need to assess a penalty per se? And do you just send a letter saying, hey, you came before the board, we saw this, and...
You have that discretion, yeah.
I appreciate someone being cooperative.
I think we were trying to go by the matrix, not to say that this was the recommendation, but it doesn't mean you have to do that.
Right.
It's a pretty big jump in severity between this and what we've levied $1,000 for today.
Right.
You know, so.
I don't want to go against the matrix. I mean, if that's what we've done, then so be it. But I just felt like a letter
I had the
of
same
warning.
thought you did. So
Kind of like just slap them on the wrist.
I honestly did too when I was pre-reviewing the cases with Wendy.
I'd like to go on the record and say that I thought the same thing.
Any consensus on this?
No.
Okay.
I have nothing to say.
All right. So what I'm kind of hearing is maybe a consensus potentially for moving this to a letter of warning in lieu of the $500 civil penalty.
I just feel like it's in your face. When you turn around and try to rectify a situation and you do that, it's kind of like, oh, and by the way, you owe us $500. You know, I don't know.
I know there's no firm history or the owners, any licenses that we're aware of.
So I think what we'll do here is I'm going to accept a motion here to just basically change the recommendation to send a letter of warning to the recipient or respondent firm with respect to this matter as the recommended discipline versus what is in the read-ahead packet. We'll be voting on all of these, but just to clarify. All right, case number 18, our brethren and sisters at the Tennessee Board for Licensing Contractors have again been active in terms of referral work for us because we have some firms that are doing review level reports without enrollment in a peer review program. So we have a series of cases here that are similar to what we've seen before. Case number 18 is one where there was a referral here from the Licensing Contractor Board. In this particular case, there's some language around it being a draft review and so forth, but the recommendation here is to the standard penalty, which is authorize a formal hearing with the authority to settle via consent order for a civil penalty of $750. This was a review level of work. I think in our discipline matrix, we've differentiated between review level and audit level. So audit, and we'll see that in a case or two, will be a recommended higher penalty. But this is, I think, is consistent with where we've typically been on these types of cases. Further comment or discussion on 18? Okay, we'll go on to 19. This is also another licensing contractor board referral. We've got a CPA with a license, but not no firm permit and not enrolled in a peer review program. There's a little background about how the respondent was ignorant of the requirements and is now more enlightened. But again, the standard disciplinary recommendation here is for a civil penalty in the amount of $750 and signing an exemption form, since he indicates he's not going to be doing reviews or attestation work in the future. Any comments or discussion on that one? Case number 19, also from our licensing contractor board. I think we just did that. I'm sorry. So on to case number 20. This is one where the board has filed a complaint against the respondent for possible peer review violations. And in this particular case, the respondent confirmed that he was providing attest services. The board did not renew the permit until the firm re-enrolled in peer review. The respondent did re-enroll, and then therefore the firm permit was renewed in February of 2019. But after that renewal, the board was informed that the respondent was dropped from peer review again in May of 2019. The background here is that the respondent has had a history of enrolling and then dropping from the peer review program since the completion of its last peer review engagement for the period ended January 31 of 2014. They've been dropped and then reinstated, and then they've re-enrolled. And basically, while the respondent states that they're working on re-enrollment, there's no evidence that's been provided that that has occurred. So typically, when we're dealing with this level of violation and this pattern of enrolling and then dropping, the recommended penalty is stiffer. That is the authority to settle via consent or authorize a formal hearing, but to settle via consent order upon the respondent's payment of a civil penalty in the amount of $3,000 for providing attest work. And in this particular case, given the history, the recommendation is also that they re-enroll in peer review and provide proof of an accepted peer review report by May 31, 2020. And we thought that there is some time that's involved in enrolling and actually undergoing your peer review, and we thought this was a reasonable time frame to provide for cutting to the chase and actually getting the peer review report done.
When was the last time a peer review was actually done for this firm? He dropped because he wasn't complying with peer review.
Yeah, January 31st of 14.
14 was the last. Because if it says here, I'm sorry, but
In the second paragraph.
okay.
Yeah, and then dropped in 2016, then reinstated, and then earlier, re-enrolled, got his firm permit renewed based on that re-enrollment, and then dropped from that.
So 14, he was covered through 17. Is that correct?
Right, so if the period ending was January of 14, the due date would have been July of 14. So yeah, he should have had the next peer review in July of 17. Would have been due by July of 17.
Yeah. And we don't know how many reports he's issued since then, or do we?
We don't, but all firm permit renewals are indicating a test work, and he has denied doing a test work.
$1,000 amount basically is a proxy for making it not worth their while to simply drop peer review.
So if he doesn't comply with this, the part that I don't see here is if he doesn't comply with this, that does the formal hearing. Is that what we're saying? Based on...
Right, correct. If he doesn't agree to
But that's just enrolling. That's not providing a peer review report, is it?
Part of the recommendation is to provide proof of an accepted peer review on or before May 31 of 2020.
Why just recommended? Why not required?
Well, I think that's a good distinction. I think it would be required. I mean, if the board committee so desires.
Again, this is quite blatant when there are several instances of being dropped.
What I'll propose for the recommendation then is as stated, except in the second line from the bottom, it is also required that the respondent re-enroll in peer review and provide proof of an accepted peer review on or before May 31 of 2020.
I want to tell you what the last peer review report said. Was it pass, fail, pass with deficiencies?
I think Sherry looked into this, whether she remembers or not. I don't know.
Yeah, I'd have to look it up to see what that was. I may not have had the information, but let me just look at it really quick. He was not very responsive in terms of, information other than he's working on re-enrolling. And this started in July. As of this morning, he still wasn't re-enrolled. I checked before the meeting.
May 31st, a reasonable date. How long does it take to get re-enrolled and get
We can do it.
Wanted to give him enough time to comply if he was willing.
required? We want to make sure it's feasible at least.
I mean, he needs to act. If he waits to sign the consent order until March, then no, it's not going to be feasible. But
he's making that choice if he does that.
Right. If he signs the consent order now and gets enrolled, and he doesn't have audit work, and he done. But
Matrix said 3,000 for failure to enroll in peer review, or is that per occurrence? What does this 3,000 represent?
I believe it's the 1,000 for the three
separate times.
3 separate times.
Stupid question, but when it says dropped, did that mean he withdrew, or did that mean the program dropped him and he wasn't eligible to participate?
that means the program drops him for not complying with some aspect of the program.
Further comments or discussion on item number 20? On to item 21. This is also a respondent that had been dropped from the peer review program. Their most recent renewal indicated that the firm does offer attest services, which requires enrollment in a peer review program. Complaint was opened because a response was not received to the earlier mailed correspondence. The respondent then reinstated the firm's enrollment in September 2019 after the complaint was open. There's no evidence that the respondent performed any attest work during the dropped period, and the firm's last completed peer review covered the one-year period that ended December 31, 2015. There was another review that was due in June 30 of 2019, but that has not been completed. So the recommendation is authorization of a formal hearing with authority to settle via consent order upon respondent's payment of the civil penalty in the amount of $1,000. Question on that one?
I have a question for Wendy, because I just was catching something here I've never really noticed. On the renewal application, is it just that you offer, is the checkbox you offer attest services, or is it you performed attest services?
It asks if you've performed attest services in the last calendar year.
Because this here just indicated that the firm offers attest services. I didn't know if that meant they actually available to do them and aren't doing them, or I just was curious about that.
I believe this one, we had renewals that said they've been doing this work.
I just was curious on the application what the actual question was.
No, it says, have you performed? Yeah.
Okay.
Other comment or discussion? We'll go on. The next series of cases, 22 through 24, relate to CPE requirements, and I think these stem from audits of the CPE environment, and we'll go through each one. The distinction here versus those that were presented earlier in the consent agenda is that those earlier in the consent agenda got their CPE, including their penalty hours, done within the timeline that was requested for them to complete that after they were notified of the deficiencies based on their audits. In this particular, in these series of cases, the distinction here is they did not get that done. So in case number 22, we have a situation where the respondent was selected for audit. Correspondence went back and forth. Ultimately, the respondent was deemed to be non-compliant and had missed the 20-hour minimum in year 2 of the reporting period and therefore incurred an 8-hour penalty. He was given 30 days to submit the 8-hour penalty training to the board. The respondent did state he never received a letter notifying of the failure to respond, and that he failed to check his email account, and said that he unintentionally failed to respond to the audit findings, including the requirement. He then responded with the penalty hours, or submitted the penalty hours on September 16th, 2019, but this was after the deadlines that had been sent out. So that's, I think, the distinguishing factor between why a civil penalty recommendation here versus a letter of warning for this one. So the recommendation is basically consent authorization for a formal hearing with a consent order upon the payment of the civil penalty of $500. Case 23. Again, another CPE audit case, and attempts were made to respond or reach the respondent. Multiple attempts that were made. Final emails were sent. She did then finally responded that she had received a voicemail the week before and would provide a response by the now final due date of August 21. As of mid-October, no response had been received. In this particular case, I'm not sure if it specifies the number of hours that were deficient here.
This is a complete non-response.
Okay.
So
we don't know how short they were.
Right.
Okay.
And they may not be short, but nothing has been provided. Okay. So this is just not responding.
Okay. So here the authorization is for a formal hearing with authority to settle via consent order upon payment of a civil penalty of $1,000 for failure to maintain CPE and failure to respond to the board. And then the last of the proposed discipline cases is also a CPE case. This is, again, stemming from an audit of CPE that was performed. Correspondence and efforts to communicate were made. Various letters were returned. Also, phone and voicemail were made. Here that she'd been selected and was required to respond. No response was received, and there has still been no response to the audit from the respondent. So here again, similar to the prior case, authorization of a hearing with the authority to settle via consent order upon the civil penalty in the amount of $1,000 for failure to maintain CPE and to respond to the board. Yes.
One question there. On 23 and 24, both, we're saying $1,000 penalty. I guess I'm just thinking back to our discussions today on other things where they did two things wrong. Failure to respond and failure to maintain CPE, two different things, or is that one?
Two different violations at $500 apiece.
Oh,
yeah.
so
based on look back at the ones previous, they're 500. So I'm saying what they did is they did two violations on each one.
I was thinking it should be 2,000, but okay.
Any other further comments or discussions on those cases?
Another question. Have we started enacting the renewals with the classes being listed? Is that in place?
That'll be in a couple weeks.
Okay, that's coming up.
Yes.
I'm curious to see how that affects us.
All right, so let's go ahead and we'll, from a committee standpoint, take action then on the series of cases that are in the proposed discipline category. Those are cases 14 through 24. And I'll just kind of go back and highlight where we made modifications, at least as best my notes exist. And please correct me, Wendy or legal, if I missed something here. But in case number 14, in this particular case, I believe here this was the fraudulent sales and use tax return. And in this particular case, I think our modification here was that we would have a consent order and we would ask the respondent to voluntarily to undergo voluntary revocation of his license until the hearing for this one. So that is a change from the original staff recommendation. Is that consistent, Stuart?
Yes, it's authorization of voluntary revocation and a $2,000 penalty.
That item in case number 16, this is the one where I think the committee consensus was to go ahead and place in monitoring status pending final follow-up on the remaining active firm permit and then the disciplinary work that will proceed in the January meeting.
Yes.
On item case number 17, The consensus of the committee there was to change the recommendation to a letter of warning from the $500 civil penalty. On case number 20, the recommendation was modified to read in the fourth line from the top of the recommendation, rather than saying it is also recommended that respondent re-enroll in peer review, it would read, it is required that respondent re-enroll in peer review and provide proof of an accepted peer review report on or before May 31 of 2020. Those are the last of the modifications that I had. Are there any others that we didn't capture?
I'll ask a question.
Sure, absolutely.
Going back to number 18. Number 18 involves a person who's not licensed or not licensed, who issued basically a review report. In that situation, I remember a couple of years ago, maybe 1 year ago, when we had a hearing for a person who was not licensed and had issued a review or maybe even an audit report. Are those, just trying to draw from my memory, is someone who is not licensed under our jurisdiction? I mean, what can we do to a person that's not licensed if we are the state board licensed? What can we legally do something to them? I mean, we're assessing.
We've done that in a lot of instances. I mean,
I'm thinking we did. Yeah.
I mean, I think it's pretty common.
There's a rule that you're prohibited from reporting on the financial position of an individual. So by issuing an audit report as a non-licensee or review engagement, any type of report normally issued by a CPA, you're in violation. Now, whether they know they're in violation or not could be questionable.
So is this 750 consistent with what we've done in the past? This is a review versus an audit.
Yes.
It just
it's consistent. Yes.
It seems a little weak for someone to be saying I'm a CPA and I'm not.
He or she did not say they were CPA, but they issued a review report.
Yeah, which implies that they think they are. So.
So with that in mind, I'll entertain a motion to accept the recommendations as with the revisions that we've just reviewed for cases 14 through 24. Is there a motion? Moved by second?
Second.
Larry, any further comment or discussion? Karen, will you please call the roll?
Aye. Larry Elmore.
Aye.
Kevin Monroe.
Aye.
Todd Skelton.
Aye.
Thank you. And then our last three items are representations. So these are cases where the board has previously dealt with the matter and there is an update for consideration on the part of the board. So case number 25 relates to a lack of evidence of peer review enrollment, but the licensee was issuing a review opinion. And the original recommendation was to authorize a hearing for the maximum penalty with the authority to settle via consent in the amount of $3,000 for failure to enroll in peer review or submit proof of enrollment. So the board made that decision. The update for this representation is that after a consistency review, it is recommended that the civil penalty be reduced to $1,000 based on the penalty guidelines. Also, the respondent provided further information that indicated that this was an isolated incident and that he primarily focuses on tax preparation and QuickBooks consulting. So the new recommendation, then there was a subsequent recommendation for that $1,000. The board then approved that. Now, the update for this one is that the respondent stated that he refunded the fees, apologized to the client. He felt that his reputation was harmed when his client disparaged the respondent to the client that referred him. And in this particular case, the respondent is questioning the reasons for penalizing a first-time offender that admitted to bad judgment and admitted guilt. So in this particular case, if we can't have a meeting of the minds, there's likely going to need to be a hearing, I guess would be the way that I would describe it. And so the recommendation from Wendy and staff in this case, before we get to that point, is to set up an informal conference with the respondent to discuss that person's concerns. It is not a recommendation to change our previously issued $1,000 civil penalty, but basically to let the person be heard short of a formal hearing under an administrative law judge and all of the apparatus that would entail. Wendy, any further comments or background on that?
Stuart's had more conversations with this gentleman than I have, so.
He wants to speak to the board or to a board member about his concerns on a penalty where he immediately rectified the issue, apologized, his reputation was hurt, and I think he just wants to speak.
Welcome to come anytime, right, and address this board, or does he have to do we have to approve anything for that, or? I mean, he's just someone that wants to address the board. Do we do that?
We've had at least, earlier in the year, we had one case where we had that informal conference short of a hearing with the respondent that was the subject of SEC discipline. And I think that was kind of one thing that was going on in the background in the discussions that I had with Wendy, that might be a way of letting the person be heard, but without entailing a full-blown hearing and the costs that are associated with that. He could also come as a spokesperson in a public forum as well. I'm amenable to that, and I'm in. I don't know where this guy's from, but if he's in the Nashville area, I'm happy to.
He's in Memphis.
Okay. I think, given that staff would be here, and we would probably want staff to participate if we did such an informal conference, he would probably need to come here, and given what he's done, I don't have any objection to that. So I guess for us, the decision item on the board is whether or not that they would be willing to authorize that type of an informal conference to see if we could.
Are we talking about him addressing the board, or are we talking about just a few people sitting down with the individual?
Well, in an informal conference like we had in the past, it's usually one board member and then the staff, and just to discuss the issues, concerns, see how we can resolve this matter.
Just that, or not? That doesn't fall under the sunshine scheme.
No, it's not. There's no notice. It's just setting up a time for everybody to get together.
Because it's only multiple board members. So
did this result in changing the discipline?
I think what Kevin's saying is no.
I don't think without board approval that we could change it, because the board's on record as saying we're going to apply a civil penalty, a consent order, either a formal hearing or a consent order and $1,000. And I guess if something new came out or revelatory, we would need that we were going to change the recommendation that exists on the books. We would need to deal with that in our January or a subsequent.
I think it would be important for us to be able to show that we've had 10 instances of this, and each time it was $1,000 for that instance. And, I mean, I'm just saying in general, just to show him that he's not being treated any differently. Matter of fact, we changed the penalty because it was not in line with the previous people, I guess, that had done the
By the same token, if he has this, do we give everyone this same opportunity? I guess I'm not opposed to giving him this opportunity, but I want to make sure everyone receives the same consideration.
I think in theory they do, because they can always appear, right? I mean, if we assess a penalty, they always have the option to come before this board and say, to appeal their whatever I'm trying to say. I mean, that
basically we're at a situation where he's not signing the consent order. So the next step is a hearing. So we can
avoid that.
And what we're trying to do, I think, is avoid a hearing if at all possible. So we're kind of at a crossroads a bit with this because,
all we can do is try to further explain why this is the penalty that's been assessed, and he can choose to agree with it or come to hearing. And
I know that in the past, like the informal conferences or hearing, not really hearing, but just a conference, it's worked out well for all parties involved.
Consideration, Pam, are we treating people equitably? And my view at this point, it's either go to hearing and all of the time and expense that entails on everybody's part, or to try to have one last go at it, convincing him that he really needs to sign the consent. Or he can still have a hearing if he wants to, and then we'll deal with that.
I think if this became problematic and became too taxing for people asking to meet, then I think we'd have to reconsider. I agree.
We don't get a lot of requests like this.
No, we don't.
I'm in agreement with Trey that I think when he sees that this consistent practice, that, okay, you're not singling me out for the first offense, this is consistent. And that's probably where he's most concerned. He feels like he's being picked on. Idea of an informal.
And also it had been higher, and so maybe he does feel like he's been treated a little less fairly than some, because for whatever reason it did start at a high point.
Well, the way I'm interpreting this, if we proceeded with that, right now the previously approved recommendation of the $1,000 civil penalty, a consent order and a $1,000 civil penalty, is still there. We have the informal conference with one board member from the board, and we'll work through with Wendy and the respondent as to timing and things of that nature. But that if we were to ever change that previously approved penalty, it would have to come back to the board for discussion. And if he's refusing to sign, we'll take each of these proposed items and just go ahead and dispatch them. Any further comments or questions on item number 25? Then I'll entertain a motion to basically read as the new recommendation: set up an informal conference with respondent to discuss his concerns and a resolution of the matter. Is there a motion?
So moved.
By Janet. Is there a second? Seconded by Todd. Any further comment or discussion? Karen, would you please call the roll?
Janet Booker Davis.
Aye.
Pamela Church.
Aye.
Larry Elmore.
Aye.
Kevin Monroe.
Aye.
Todd Skelton.
Aye. Okay, we'll go on to case number 26. This is one that the board heard previously and authorized a civil penalty in the amount of $5,000 for using the designation of CPA without a valid license in Tennessee or reciprocity through another state. There's a lot of background on this, but the nub of it is that Illinois, where this person basically resides or has a CPA designation, allows that designation to be used in certain circumstances, whereas Tennessee would not. And so the board dealt with that case, approved a $5,000 civil penalty. There was then some follow-up discussion with the respondent who evidenced quite a bit of contrition over that, and who now understands to a greater degree what his issues were. He now lives in Georgia. He no longer provides any accounting services in Tennessee or to Tennessee residents. He is still trying to have his Illinois license reinstated, but is having difficulty maneuvering through their legal and reinstatement processes. And so the new recommendation here is effectively to recommend reducing the civil penalty from the previously approved $5,000 to the recommended newly recommended amount of $1,000 in light of the further follow-up that we've had with the respondent. And Wendy or Stuart, do either of you have any further background based on your communications with the respondent?
I've spoken to him many times, and it was basically I had to explain why he cannot use CPA, and then where he needs to remove it, and he finally he removed everything, just like I requested. Is in the process of trying to renew his Illinois designation license. So I felt like we need to keep it with the matrix on this. So this right here would have been $1,000 penalty, just like we've done in the past. Operating.
Whereas before, I think we did not know that he was cooperating, or we hadn't had that meeting of the minds. Is that right?
We didn't really have a meeting of the minds, and I think the board felt like that he wasn't cooperating, and he was he just didn't want to cooperate. But when I spoke with him, he was very cooperative with me.
Further comment or discussion on the newly recommended penalty for this one? Is there a motion to accept the newly recommended penalty, which authorizes a civil penalty in the amount of $1,000 for using the designation of CPA without a valid license in Tennessee, or reciprocity through another state, which is the standard disciplinary action? By Pam, is there a second?
Second.
Seconded by Larry. Any further comments or discussion? Karen, would you please call the roll on this one, number 26?
Janet Booker Davis.
Aye.
Pamela Church.
Aye.
Larry Elmore.
Aye.
Kevin Monroe.
Aye.
Todd Skelton.
Aye.
Okay, that motion carries. And then finally, case number 27, which is a representation. In this particular case, we have some additional information relating to the issues at hand. And so we had some further investigatory work performed on the complaint documents and the report that was prepared by the investigator. And there, basically it follows that there was a disagreement between the complainant, who was a former employee of the respondent, and the partner in charge on the engagement. There's evidence of discussions between the two parties about the proper treatment of certain loans. It basically, was an accounting issue. There was no evidence in the investigation report that would support allegations of fraud or fiscal dishonesty by the respondent. And so the original recommendation was to refer the complaint to litigation for a formal hearing for the revocation of the respondent CPA's firm permit. However, now based on further investigatory review, there is not sufficient evidence to determine if the respondent materially misstated items in the financial statements. These also apply to 2012 financial statements, which are dated. To attempt to relitigate this or to reopen this up and to try to really get to the facts that may have occurred would be difficult. There are some considerations there. The firm has subsequently enrolled in peer review and is in compliance and has had no further issues that have come out of the respondent's peer reviews. So at this point, the revised recommendation is to close the complaint. And any further background, Wendy or Sherry or legal, that we ought to be considering here?
I would just say, after reviewing Don's report, and that is all I did in this case, I didn't reach out to the parties of the complaint, but after reviewing the report, it was clear that there was a difference in opinion between two audit engagement team, and that was documented, reasons for, disagreeing with. And so, in my opinion, that's one person's professional judgment over another. And at the end of the day, the engagement partner is the one who, makes the final decision on that. Is the kind of the approach that I came from that. And I saw nothing that would, definitively say that they were intentionally misstating financial statements, which was what was part of some of the original allegations of the complaint.
This complaint is really several years old, is it not?
Yeah,
if you're looking at Don's report.
I was going to say the complaint was filed in 2014, referring to 2012 financial statements.
I think part of the issue here is it's very difficult to really pick this up now and make a case one way or the other. And then based on what we saw in the originally prepared report, your view or recommendation, Wendy, and yours, is that there's not enough to proceed with. So the recommendation is to close.
I would say the reasons for having the person the complaint was filed against, their reasons for treating these things seemed reasonable on the surface.
And what caused it to be brought back up? I'm not. Why are we talking about it again?
I think, and Wendy, please chime in. This was when I first came on board. This was still hanging out there, and there were some efforts because of the backlog to bring Don back to continue the investigation of it, and then none of that transpired. Do you have anything else to add to that?
It was Don's investigation. He left, so that caused a problem. It was very detailed, and so at the time we thought we'll just bring him back as a contract person to help us with the hearing on this, and let Sherry work on current investigations, and then our attorney at the time, Sarah Page, worked on that contract with Don, which took a while. Then we lost Sarah, and now we're here where we are today, basically, and we're looking at it thinking, do we have enough to prove a case in a hearing? And what else the intent was, let's give it to Sherry and figure out what do we need to do to prove this case to the board. And when she looked at it, I think she just felt like there's just not enough there to prove to the board in a hearing that there were violations.
So, this was 5 years ago.
Right. The initial plan was it would come to hearing, and that's what we had planned on doing for a good while, based on Don's report.
We have others of these that are just hanging out there like this?
No. This is it.
Okay.
And the respondent hasn't had any communication as to status of this and all this time?
No.
So if he is he going to get something and
now, yes. Based on whatever decisions made here, yeah.
But we can really do anything else at this juncture with what we have. It would be difficult to reopen a case that is that dated. And it looks like from at least the documentation we have, it's not open and shut or clear cut that we have a case.
There's just no evidence to support the initial allegations of the complaint, which were fraud and fiscal dishonesty by the respondent, the CPA firm. Now, it could be reviewed for possible standards violations or something, but even then, as I read through the documentation that I had, there seemed to be valid reasons for the partner's stance. This was basically a complaint that was filed by a senior accountant at the firm against the firm, an engagement partner. Effective.
Follow up and say, hey, why haven't you responded to me? Or I'm just surprised that there hadn't been some kind of if he thought enough to raise the question, I'm surprised that he didn't come back later, at least a year or two down the road, or 3 or 4 years down the road, and say, hey, what's going on with my complaint?
The complainant did reach out quite a bit when Don was still here. And then I don't recall if they reached out after he left or not.
I've received no correspondence.
Further comment or discussion on this one in the revised recommendation?
I would just suggest that if we have something like this in the future, that it land on some kind of report that says, here's this report that's still sitting out there. That thing that we have that we look at every month that shows statistics, shouldn't it have been on that report somewhere?
I guess we don't present it in a way that shows you when the case was opened to give you a length of a sense of how long something's been open.
To the extent that we have some aging in the existing open complaint portfolio, that might be a good helpful fact to include with the complaint statistics that we get. Excuse me.
Bless you.
Thank you. With that, I'll entertain a motion to accept the new recommendation, which is to basically close the complaint.
So moved.
Moved by Janet. Is there a second?
Second.
Seconded by Pam. Any further discussion or comment? Karen, would you please call the roll?
Janet Booker Davis.
Aye.
Pamela Church.
Aye.
Larry Elmore. Kevin Monroe.
Aye.
Todd Skelton.
Okay, thank you, Karen. And thanks to the committee members and also the entire board for working through a long bevy of different cases here, and appreciate all the good input and comments and wisdom there.
One more comment on that. I don't mean to beat a dead horse, but will there be something in our records or something will there be something that says 5 years to do this? I mean, if somebody came along and looked at this report and said, this thing got deferred or closed 5 years after it was filed, should we document this some way that here's what happened?
I think there would be some documentation of the action that the board will take that it's closed.
I mean, the legal reports are part of the public record, right? I mean,
Yeah, they would just look at the legal report to determine what happened based on what's
that relates to this.
Yes. The one that you're looking at right now.
But that history's not here as to Don left, and we kept thinking, I mean, I'm thinking there should be something to document.
I would think that the minutes of the meeting could reflect the discussion that we had concerning the staff turnover. And
tomorrow, we could make some type of announcement because of X, Y, and Z. So it's on the record, and I believe this is on the record.
for your information as well, we all have monthly meetings, and I know that's not shared with you all, but we also have quarterly meetings with the head of the legal division and the assistant commissioner, so that our folks aware. We're not trying to hide anything.
Oh, no, I wasn't
Okay.
implying that you were. No,
Okay.
no. Please don't take
Okay.
that. No.
Okay. And this is like the last, I mean, there's nothing remotely close to, this has been kind of the problem child that we've been trying to figure out how are we going to handle this one.
So do you all have some kind, I guess it sounds like you have some type of aging or tracking of.
Yeah, we have what we call a case and complaint report that has the names and status of everything, how old it is, status it currently is in. You can sort it, and so we meet monthly and talk through those, every single one, and then quarterly we meet with higher-ups to report on those. And they typically look at only older ones.
So you all are tracking it, but yeah, I think Larry, you make a good point that it would be good to highlight that somehow through the
Okay.
complaint report that we get,
Okay.
so that we're aware of it.
Well, I might be able to modify the case and complaint report to remove the data that
That's
you
ever
can't,
an issue
that you're not
again.
supposed to see, and then you can see from there. Yeah.
Part of the confusion is it says in that last paragraph, it says the reopening of this complaint. Well, it never was really closed, was it?
Yeah, that's not really the most accurate way to say that.
It says it would be challenging to reopen the complaint, but I guess in my mind it never was opened, or never was closed, I mean.
It should just say that the actual taking that complaint to the hearing would be challenging. Pursuing the hearing and everything would be challenging based on the evidence that we see.
that might be a recommendation or modification that we would include in that synopsis. So
That's why I asked my original question, what caused this to be brought back up? I was reading that last paragraph, and it says the reopening would be difficult, and I'm thinking,
I guess that was meant to mean reopening for investigation. So, but that's a good point.
The aging made us look at it again and decide. I know that in our monthly meetings, we decided that we wanted to look into it again and investigate it and make sure, do we need to take this to a hearing, or are we missing something? And that's when it was requested for Sherry to review.
I'm done.
Back for just a second. On if the tracking spreadsheet that you maintain is too hard to redact to provide in a proper format, I would think something that, even if it's just showing in buckets of, here are the ones that are 6 months old, year or 2 years, or more, whatever the appropriate thresholds are, would be useful for me, if that's an easier way to do that than trying to carve up something else.
Thank you, and Wendy, we'll defer to you on judgment as to how to best present that, with relative ease, but still provide the board with the requested information.
Read our minds.
Sorry to draw this out, but I was reviewing this and I just remembered September seemed like we had a lot of complaints, but we only closed 2, and that was a lot lower than what we usually do. Is it just a timing?
It can be closed till they're heard in front of the board. Is that correct?
Some the last time, right?
Right. I mean, it has to be presented to the board for closure. If we recommend closure, then you have to vote on it.
So in September, we opened a lot. That's when all the rush of CPE happened. And then closures are when people sign a consent order. So even though you all may have made decisions in July, if we don't get anybody that signs and returns a consent order, it's still open. And so,
I apologize. I was thinking of something else, like actually voting on closure, but you're talking about on the report.
Complaint report.
Yeah, those are ones that actually sign the consent order, pay the penalty or whatever that was recommended, and now they're closed.
Follow up. I think we're ready for laws and rules, and the prospective members of that committee are Chairperson Janet Booker Davis, Andy Bonner, Larry Elmore, Trey Watkins, and Judy Weatherby. And so, Janet, I'll turn it over to you.
Well, this should be very quickly. For me, anyway. I don't know about Maria. But we only have one item. It's an informational update on the continuous testing rule. And I think Maria is going to speak to that.
Yes, so the continuous testing rule, last time I think I had let you all know that it was submitted to the AG. Since then, we've got the Attorney General's approval, the Governor's Office approval, and now we are scheduled for, it's been filed with the Secretary of State and posted. The rulemaking hearing is scheduled for December 19th, and the proposed effective date, given that everything goes well at GovOps, will be on January 15th, 2020. And this isn't on the agenda, but I did want to note we went to GovOps for the CPE and nano learning rule, and that was on August 21st. And the effective date for that rule was September 4th, 2019. That's all I have.
And that is all this committee has.
Okay, thank you, Janet Booker Davis, and thank you, Maria. Okay. We'll go to our last committee of the day here for the Executive Committee. There's only going to be one action item, but that is an important one. It's the review and approval of the 2021 fiscal year budget proposal, but we also have some background just with respect to the closing of fiscal year 19 and where we are year to date in fiscal year 20, and then also just a travel update. So for those, I'll turn things over to Wendy.
okay, so the first item is your FY19 year-to-date financial results. Oh, wait a minute. Where did I put closing? I'm in the wrong month. So. Okay, FY19 closing is the first document. And we just finally received final closing numbers for FY June 30, 2019. Our total revenues ended up at $972,645 after the state reg fee was taken out. Our total expenditures were at $901,818, giving us a surplus for the year of $70,827, and that rolls over to our reserves, which now has a balance of $1.253 million. We are doing a little bit better. Last year we put $81,000 in reserves, and the year before we were at $219,000, so we're getting a little bit closer to where we'd like to be. You'll notice our cost backs landed in the total department at $277,000, $625,000, which is just slightly less than the prior year. So are there any questions there on how we ended FY19?
One thing I would just note, earlier in the summer, Wendy and I appeared before the Joint Ops Committee of the Legislature for our sunset hearings, and we were there along with numerous other of the 27 or 29 or thereabouts boards that they have jurisdiction over, and there was some commentary made on certain of those boards' reserve balances relative to their total, and I know we've had some discussions, Trey, and you've made some points earlier about that. Just my read of that is that there did not appear to be discomfort with our current level of reserves, which are just slightly over 1 year's worth of operations. There were other entities that had reserves that were multiple years of their operations, and they got a little bit more attention, appropriately so, from the folks at the Joint Operations Committee. And so I felt pretty comfortable when I walked out of there that we were in a very comfortable space with respect to our reserves.
And still doing our best. The department is still working on ways to pull money out of there for technology improvements. It's anything with government, it just takes a while, but that's still at the top of their list, and hopefully we can make that happen in the next 6 months or so.
Well, the other wild card I think that we have, which causes me to want us to be a little conservative, is we don't have much control over our legal expenses. If we have multiple hearings, that's going to take a chunk out. There are just some unknowns that we can't control, but we've got to be somewhat prepared for.
In theory, we charge those fees back, right? Don't we charge the cost of those to the respondents?
Well, I guess in some cases you may. We have not recently.
We have not. We haven't had when was the last time we had
We haven't had one in a while, right?
Since our marathon that last time?
Yeah. Had the lady from Memphis. Okay, so the next item is your FY20 year-to-date operating expenses. So we are really only 2 months into the year, so and I think we're doing fine. We're on track. I guess the few items I'd like to note is we are a little behind in revenue, but again, we're so early in the fiscal year to be too worried about that. Travel is a little bit down. Cherry, I don't think has traveled at all this quarter for investigations. We just haven't had a need to do that. Third-party professional administrative services, that looks to be significantly more than the prior year, and that's simply because our NASBA dues hit a month earlier than they did in the prior year. So that's $6,000 of that line item of third-party professional services. In state professional services, that is much lower than the prior year, but they're just behind on assessing some costs to us. So we have not seen rent and some IT costs yet, and the same thing with cost backs. We just have not seen all of the expenses that I expect that we will see yet. The one thing I will note is that I do feel like our legal costs have stabilized a bit. So when referencing this year compared to last year, we are down $11,800. So I think that's, it's still going to be on the higher side, but it's not quite as dire as we thought that it may be. So I think that's one thing to note. The other thing I guess I'll note is that this is Stuart's last meeting with us.
He is our legal counsel.
May double, we'll see.
Maria is going to begin handling all matters related to our board, so we won't have so many attorneys maybe around. So we will be going directly to Maria for discipline and program matters. And Stuart's still going to be around, just taking on more of a supervisory role, and so he'll be around for some guidance. So if there are any questions related to current year, happy to take those. Okay, so the last item that we do need to take some action on is, I skipped the travel report. Travel report's very simple. I had one trip earlier this month, and that was related to the AICPA State Board Committee, and the state is actually being reimbursed for those items, so it doesn't end up costing the board any, but does show up on the financials. Okay, so to the budget document. So FY21 proposed budget. So if you open up this document, you're going to find the budget document. You're going to find an attachment A, which relates to personnel budget, attachment B, which relates more specifically to travel, and then a discussion of those line items. So really, with regards to revenue, I'm projecting flat to FY19. So we kind of always look at the year that's comparison to the licensees renewing. So every other year, we are, this is an odd year that we're budgeting for, so I take the last odd year and I'm projecting flat revenue there. Keep in mind, we do not include the any case and complaint in the budget. So case and complaint has ranged anywhere from 18,000 to 50-some thousand over the past few years. So that's kind of bonus money when that comes in. So that'll be your difference between budget and what you've seen some of the actuals look like. State reg fee is a standard regulatory fee for each license that's renewed or issued to active status. Firm permits are also charged a fee, and that's pretty typical and easy to budget for. Salaries, I am assuming a staff of 4, the executive director, and 1 investigator for a total of 6 individuals. There's no change here, and we're assuming a 3% compensation increase. And the details of that can be found in attachment A, and brings our salaries at $354,839, longevity at $6,000. Employee benefits is typically calculated at 37% of salaries and longevity. However, we've been running a little higher there, so I gave us a little extra in that line item. The travel budget is outlined in attachment B and is consistent with prior years. I did ensure that we included 4 board members at each of the NASBA events. So if you recall from prior meetings, whatever the board approves is what we are allowed, what the department is approving us to do. So if we approve 4 members to go, they should be approving those 4 members to travel. So if we have a 5th person that wants to go, that likely would not get approved unless the board comes back and approves that. Communications and shipping, standard there. Supplies and furniture, with our electronic nature of our jobs now and AWS, we just simply don't order that much anymore. So ordering there. Rentals and insurance, that's for any car rentals. If I travel in the state anywhere over 50 miles, I have to rent a car now. So I'm in an allotment for that. Awards, unclassified was the professional privilege tax for certified employees. We do not have that any longer. Employee training, this covers CPE for professional staff as well as our registration at NASBA events, which is $695 per registration. Computer-related activities have not been that much of late. However, we will have to replace computers as the state advises. Apparently, they're on a plan, and they will come to us and replace the computer whenever they feel it's necessary.
State professional services. Now, we are going to save some on rent here, which is great. Unfortunately, the increase in IT costs is going to diminish any savings we're going to see on rent. So I did not, in fact, I really took that as flat to FY19 due to that. I kind of calculated the amount we had spent in IT over the past year under this revised plan, and we were at close to $20,000, which is what we're saving in rent. So, and then I may be a little low on cost backs, but I did bring us in at $275,000 in the proposed budget. And that's just kind of a shot in the dark sometimes as to what to expect there. But the overall budget, I'm proposing revenues at $938,000 and total expenditures at $947,000 for a negative $9,424,000. We almost certainly will see some case and complaint revenue for that difference.
Thank you, Wendy. Any comments or questions for Wendy on the proposed fiscal year 21 budget, which is an action item, I guess, that the executive committee will vote on this afternoon and then the full board tomorrow?
Just a question. Does this budget go up to the commissioner's office, or how does that? Do they approve this?
I submit it.
Okay.
I don't usually get much.
The only reason I'm
response.
asking is when we present these as a deficit, I'm just curious how they react to that.
Oh, they didn't react last year when I submitted it. But the statute does say we're supposed to submit it and receive an approval from F&A, and I've never been able to get that far in the process. But they do, for all other boards, they assign spending plans, and they take your approved budget, and we use that instead of being assigned, obviously, a spending plan. So.
Quick question on travel. I was just looking at our historical actual averages about, 31,000 or so. Do you think the budgeted number's too high, or do you expect it to be a lot more this year? I know we're going to have additional board members traveling, but do you think it'll be 10,000 more?
I leave room in there for some unexpected things, but typically we're probably going to be maybe $5,000 less than that, if not everything pans out. So, I'm sorry.
I was just asking if we can get back to just a break-even budget rather than a deficit. That was just one area I saw.
Okay.
If nobody's looking at it, I don't have a problem with it. I just was curious. I mean, if nobody's going to approve it, then
Coming in at like 1% of the budget amount, which to me is pretty tight.
Right.
I'm okay there.
I'm sorry, what was your comment, Kevin?
Well, the proposed deficit for fiscal year 21 is just a tad over $9,400, which is about 1% of our expenditures.
Total, yeah. Okay.
And then you said it doesn't account for any fees or cost that have been assessed, penalties, right?
Right, case and complaint revenue, correct.
Okay.
I believe we will be in the positive. I was asking why this was. Never mind.
I'm fine with everything else. I'm fine with the budget.
Thanks, Stephen, and also thanks especially for hanging in there on the phone throughout the afternoon. I know that's not the
Keep reminding us you're there.
I've been asleep. Y'all doing great.
Why did you say the case and complaint revenue isn't included?
So we're not supposed to count on that revenue. I believe it could be an appearance that you are, the board
Right, to achieve a budget by projecting
right,
penalties
being
and
supported
fines.
based on the penalties and fines, which we don't, it's not what the goal is.
We want to assume everyone's going to be compliant when we won't have any.
Well, and also you can assess all the penalties you want, but they may not pay them or they may not consent to them.
Unless anybody has more discussion, I would make a motion to recommend passage of this budget to the board tomorrow.
Thank you, Stephen. I should have also mentioned earlier that the members of the executive committee, or the proposed members, are myself as chair, Stephen as vice chair, Gay as secretary and Trey as immediate chair, still
Not very
serving on the
immediate.
board.
The most
In about 6
So
years.
with that motion, is there a second?
I'll second.
Seconded by Trey. And Karen, would you please call the roll?
Stephen Eldridge,
Yes.
Kevin Monroe,
Yes.
Gay Moon, Trey Watkins.
Yes.
Thank you. That motion carries. I think I have no further business for any of the committees at this point. So unless there are any things for the good of the order, we'll adjourn until tomorrow morning. And let me just make sure when we convene tomorrow at 8:30 a.m. And we will be in 1A. Is that right? The other room tomorrow. Thank you, everybody.
Call it number the same.
I believe Karen is still working on that. So just
Well, I'll just wait for an email. We'll work it out.
okay. We're trying.
All right.
Thank you.
All right. See you guys.